You're watching The Legal Breakdown. Glenn, we've got a major court ruling against Donald Trump, definitively, which you'll talk about in a moment, one that is going to eventually find its way up to the U.S. Supreme Court. Can you explain what just happened?
Yeah, Brian, very quickly, this case just got teed up to be a major case before the Supreme Court in the very near future. And here's why. There have been a series of firings by Donald Trump that have been flat out unlawful. And you don't have to take my word for it, because just as in the case we're about to discuss, Trump's DOJ lawyers are actually going into court and admitting they are unlawful. But they're saying, we think the Constitution ought to be changed and not give Congress the authority to pass laws that set fixed terms for executive branch employees and say that those people cannot be fired on a whim by an incoming president. They can only be fired for good cause, for neglect of duty, for malfeasance in office, and they can only be fired after notice and a hearing. But lately, Brian, Donald Trump has been firing people on a whim, not for good cause, and without giving them the required opportunity for notice and a hearing on the issue of their proposed determination. So in this case, it is a case that was brought by a woman who had just been fired by Trump unceremoniously, no notice, no hearing, no indication that she had fallen down on her duties. Now, what was she doing? Well, she was appointed as one of three members of a board for the Federal Labor Relations Authority, the FLRA. She gets a 5-year term. And Brian, mind you, this is under a law that was passed by Congress and signed into law by the president. And for nearly 100 years, the Supreme Court has said, yes, this is within the authority, within the constitutional prerogatives of Congress to put these people in place for 5 years and requiring by federal law that they can't be removed except for cause. And now Trump, one after another, is saying, I don't care. I'm violating the law because I want to get these cases up to the Supreme Court, and I want the Supreme Court to revisit the law and say that I have complete and absolute authority, and Congress can't tie my hands by putting these qualifiers on people who are working in the executive branch. So this case was just resolved, and something called summary judgment was entered. What does that mean? It means that the judge, the presiding judge, Judge Suknanan in D.C., said, okay, I've heard enough. I've seen the briefs. You've made your arguments. I don't even need to hold evidentiary hearings because I am ruling that this was an unlawful termination of this member of the FLRA board. And indeed, it was easy for the judge to reach that conclusion, Brian, because even the DOJ lawyers went into court and conceded this was an unlawful termination. But they say, we don't like the law, and we want to try to get this up to the Supreme Court so they can change the law and give Donald Trump nearly dictatorial power. And just give me one more minute, because I really want to read a little snippet of Judge Suknanan's opinion, because it is forceful, it is direct, and it is unflinching. The judge says, the government, meaning the DOJ lawyers in court, the government vigorously defends Miss Grundmann's hasty termination. Miss Grundmann is the board member who was unlawfully terminated. And the lawyers vigorously defend that termination, arguing that the president may remove federal officers on a whim, and in doing so, override Congress's considered judgment. The government, the DOJ's lawyers' arguments paint with a broad brush and threaten to upend fundamental protections in our Constitution, but ours is not an autocracy. It is a system of checks and balances. And then she puts an exclamation point on that by saying, we abide by the constitutional prerogative of Congress to do this, quote, to save the people from autocracy, close quote. It doesn't get any more pointed than that. And Brian, this case is now headed like a rocket up to the Supreme Court, I suspect.
And Glenn, in terms of the Supreme Court being able to see this, I mean, you just said this is law. This is, and I believe this is Humphrey's executor. Is that the case that this is all based upon? Is that correct?
It is. It's the Humphreys executor case, kind of a curious name for a Supreme Court case. It's 90 years old. It was decided in 1935. And what it all boils down to is Humphreys was an executive branch official. He claimed he was wrongfully terminated, and he died during the course of the litigation of that wrongful termination suit. So his executor stepped in and finished up the case. And the Supreme Court said, no, the Congress has the power and the authority under our constitutional separation of powers and checks and balances. They have the authority to do this. And Donald Trump doesn't like it one bit. I mean, he is forever sort of reaching for more and more and more power. And this judge called him out and said, the reason we have the Humphreys executor Supreme Court ruling and other rulings that have followed along those same lines is to, quote, protect the people from autocracy. And here we are.
Well, in that, look, I get that this Supreme Court is not sympathetic to settled law, right? Like, even though they went on and on about stare decisis and how it was the most important thing in the world, and they couldn't possibly touch Roe versus Wade, only to do exactly that once they actually get a seat on the bench. The difference is that Roe wasn't protected by statute. It was a Supreme Court precedent, but this has been a statute for almost 100 years. And so how does the Supreme Court have the right, really, to go in and overturn statute without Congress being the ones to change the law?
You know what, Brian, saying that the Supreme Court is not fond of settled law, or they don't feel bound by settled law, is probably a pretty dramatic understatement,
Yeah.
as you just pointed out, in how they flip-flopped on Roe v. Wade versus Dobbs when they revoked women's constitutional privacy rights to make their own reproductive health decisions. So you ask the question, well, what might they do here with something that has been settled for nearly 100 years? You know, it's anybody's guess. And I wouldn't, place my $1 bet on how this case will turn out. But here's what I will say, and we're always looking for points of light. The most recent case where the Supreme Court had to decide whether the Trump administration had overstepped its authority, had done something that the law and the Constitution doesn't permit. It was the U.S. aid case where Donald Trump's administration had stiffed a bunch of contractors who had submitted invoices for work already performed or goods already delivered to the federal government under existing contracts.
That sounds like a recurring theme in Donald Trump's life.
Yeah, who would have guessed that Donald Trump would continue stiffing contractors when he transitioned from being a businessman to being president? But what did the Supreme Court do? Well, two justices crossed over and joined the liberal bloc. It was Chief Justice Roberts and Justice Amy Coney Barrett, and they ruled against Trump's expansive view of the executive's power. And they said, no, basically, pay your damn bills. That is a good and hopefully that's a good sign, and hopefully it's some foreshadowing for how this Supreme Court will now begin to assess Donald Trump's determination to forever expand the power of the chief executive. So I am very guardedly optimistic that they will stick with nearly 100-year-old precedent and say, no, the Humphreys executor case, the power of Congress to protect the people against autocracy in this very way will continue to survive and hopefully thrive, because we need it now more than ever.
Glenn, I know that this case specifically was narrowly focused on the plaintiff, which is Susan Grunman at the Federal Labor Relations Authority. But there are other folks in analogous positions who have been fired who could make the same claim here. So does this precedent count only toward this one plaintiff, or is there a way to more broadly have it so that this precedent applies to all folks who are in a similar position?
Yeah, great question. So let me unpack that a little bit. First of all, this is a trial court decision by one federal district court judge, Judge Suknanen. So that doesn't serve as precedent. Now, it can be persuasive because the rationale that this judge used could certainly be adopted and used by other judges who, as you're saying, are literally involved in litigation involving not just analogous, but almost identical cases. And here's the thing, Brian, Judge Suknanen actually acknowledges that in her written opinion. She says, look, Congress has this authority to set terms for executive branch officials, to require that they can only be removed for cause, not on a whim, and only after notice and a hearing. And what have we seen in the last couple of months? We've seen inspectors general who enjoy those same congressional protections under the law, terminated at will, violating federal law. There's a special counsel who's actually sort of an overseer of many of the inspectors general who was terminated, who enjoys some of those same legal protections for his position. So the answer to your question is, in part, yes, this will be seen as persuasive authority because it involves identical facts and identical protections put in place by Congress that the Supreme Court has consistently ruled are lawful and constitutional exercises of Congress's power. So I have a feeling this rationale, though it's not technically precedent, because precedent is only set in the appellate courts, it will serve as what I like to call atmospheric precedent, and it will be an important consideration in all of the lawsuits brought by similarly situated, wrongfully terminated executive branch officials.
Which brings me to my next point. Shouldn't other folks who've been wrongfully terminated see this decision being handed down, and shouldn't this be an impetus to bring suit against him if they haven't already?
Yes, but remember, lots and lots and lots, tens of thousands of the people who are being wrongfully terminated, like probationary employees and some prosecutors who worked on J6 cases, they are not benefiting from these congressional statutes that give protections only to very specific members of the executive branch, like inspectors general, like members of certain boards, like the FLRA, the board we're discussing here, and a handful of others. So it's actually a limited universe of people who have those protections under the law, but all of them who are wrongfully terminated, I'm with you, should look at this, should be emboldened, and should be encouraged to bring suits of their own, if they haven't already, many have, for their wrongful termination.
Is there a world in which all of these folks can come together if they are at least protected under the same general statute, that they can come together for a class action lawsuit?
Okay, I am not a civil litigator, and I've never put a class together in a civil litigation case. So with that caveat, my sort of informed opinion, knowing what I know about class action litigation, is probably not, because there are different statutes in place that govern different executive branch employees. If you're an inspector general, you're going to be covered by one federal statute. If you're a member of the FLRA, another. So you could probably join in with like mini classes, but I don't see all wrongfully terminated executive branch officials being collected up in one class action civil suit. But I will leave that for the experts.
Well, look, class action suit or individual suit, I think the point here remains the same, which is that clearly there is some positive reinforcement for these folks who are looking to take legal action against Trump. This case right here with Susan Grunman is a testament to exactly that. And so I hope that folks who have been wrongfully terminated can see what's happening in the courts right now and can take action so that they aren't wrongfully terminated, so that the government isn't staffed with only people who are going to be loyal to Donald Trump, and that we have some folks who can serve as bulwarks against the worst excesses of this administration. So look, we will continue to focus on this. As we said in the beginning, this is very likely to make its way all the way up to the Supreme Court, so we'll stay on top of it. For those who are watching, if you want to follow along, and if you want to support our work and independent media more broadly, please make sure to subscribe. The links to both of our channels are right here on this screen. Glenn is fast on his way to 1 million subscribers, so if you haven't subscribed to his channel yet, please make sure to hit the subscribe button. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.